Well, I think we have agreement then that the rules apply with equal force in the public and private sector, but that's not to say that the stakes are precisely the same or parallel, nor that the consequences are precisely the same or parallel. And perhaps you can address yourself, both of you, to that issue and the systemic fallout.
Sure. Well, in terms of consequences, I don't know if you mean to refer to Mr. Estrada's point that this all has to be considered in the context of the post 9/11 world and waking up and seeing 3,000 people dead, and of course it does. But Mr. Estrada also kind of went back and forth on whether lawyers should be giving legal advice that is inflected by policy advising or not, and this strikes me as a policy concern. To the extent it is relevant to legal interpretation, it has been built into the law. There are lots and lots of domestic and international rules about torture, interrogation, treatment of detainees that are specifically intended to take that downside risk into account. The Torture Convention has a non-derogability provision which says no national security emergency, no matter how severe, can justify departure from the obligations of the convention. And there are criminal law doctrines of necessity, which were in some of the OLC memos, which also pretty clearly are applicable here. I don't think there's anything wrong with lawyers taking that stuff into account to the extent it bears on legal interpretation. Now, we can have a long conversation about what bears on legal interpretation. Is it just the text of statutes? Is it just, how narrowly do you read cases? When do these policy considerations come in? This is an interesting question in the abstract, but in actual concrete cases, there are answers. Lawyers are familiar with these areas of law, and they know to what extent these considerations come in and affect interpretation. There is a craft of lawyering that constrains what counts as a good legal argument and what doesn't, and that can be complex and hard to theorize at an abstract level, but it means something in particular cases. And so the post 9/11 context is something that is built into the governing law. So when lawyers provide, as Mr. Estrada said, technical legal advice, they are taking into account these policy considerations to the extent they have been built into the fabric of the law. And all of the law in this area takes this context into account. That's the whole point of having law regulating torture and humanitarian law of warfare and things like that. This legal regime has been constructed with this situation in mind.
Professor, perhaps before we go on with the response, you could bring this down to the level of the concrete with one of the examples that I raised in my introduction. So far, we've been talking at a high theoretical level about power versus authority and interest versus legal entitlement, and what the center of the mainstream legal meaning might be, and how we apply that as a standard in these cases. Perhaps you can pick one of the examples and just explain how it might play out. You can use the interrogation issue, the military commissions issue, surveillance issues, Guantanamo's legality, whichever one you'd like.
Sure. Well, the definition of extreme pain is kind of the one that everyone always talks about, and the use of the Medicare statute to interpret that. I think that's in some ways kind of been beaten to death. Maybe I'll take a different one, which is the application of Common Article 3 to al-Qaeda detainees. And this is getting a little bit outside of my area of expertise here. But my understanding is that the structure of the Geneva system, including Common Article 3, is intended to create a kind of gapless coverage system, so that it's not the case that anyone can ever fall between the cracks and be an unlawful actor for the purposes of the non-applicability of Geneva protections. There are unlawful combatant rules in international law for various other purposes, like universal jurisdiction, but not for abrogating coverage of Geneva. And so the memos that use a fairly tendentious, okay, that's a conclusion, I can't say that, a somewhat formalistic approach to the Geneva system to conclude that this was not a war of an international character, these were unlawful combatants, there was not reciprocal compliance with Geneva, and therefore al-Qaeda detainees did not deserve the protection of the Geneva Conventions. That's the kind of thing that I mean by an interpretation that just doesn't work in the mainstream of the international law community that knows something about this. Now, I know the response is going to be, yes, but they've got it wrong, and we need to be a little more creative about this, and that's where I was careful to say that lawyers can rely on that provided they identify this as a somewhat adventurous argument and provide some advice and disclosure to clients, and also full, candid discussion of counterarguments. I would have no problem with a memo that said, this is an argument that we could rely upon. It's kind of out of the mainstream. Most people disagree with it. A strong counter-argument is that, for example, Geneva is intended to provide a gapless coverage system, and that's kind of generally accepted among international lawyers. But we can give this a shot. We can try this, but there is a risk, and these are the arguments that will be raised. That would seem to me legal advice that fulfills the obligation of candid, independent legal advising, as opposed to saying, with certainty, these detainees do not deserve any protection under Common Article 3. That's the kind of thing that misstates the applicable law by not disclosing counter-arguments and not providing information about how out of the mainstream that is. Again, someone's going to jump up and say, that's not exactly right. The trouble with doing the ethical analysis in the way I suggest doing it is that it touches upon all of these different substantive areas of law, and so one has to know something about all of them, and I don't. But I would propose that this is the kind of argument that we should have. I'm not holding myself out as an expert on international law. I'm just saying this is the kind of argument that we should be having.
All right. First, just sort of 3 general points. What does the rule say? Now, the rule says in its second sentence, which I read, that there may be moral considerations to a legal problem, and a lawyer may bring them to the attention of the client. It is not a disciplinary violation if he doesn't, especially when it's more than apparent that the client is painfully aware of them. The second question is the construct of what a mainstream of legal advice would think about the question at issue sort of assumes that we're talking about a set of legal materials that we all can agree on. And that does require a fair amount of technical parsing, and if you will, however, derisively you mean to characterize it, a formalistic parsing. Some of us call that law. And so just to take an example of one of the things that you identified in the first part of your answer, you said, well, look, I mean, the law itself may contain moral guides. Maybe. Sometimes it happens. Sometimes then, the government lawyer, like any other lawyer, would have to take that into account. The examples that you gave seems to me a little bit off point. You started out by saying that there are certain aspects of the Convention Against Torture that say that some of the principles are non-derogable, for example, and that's true enough. There's this other legal rule, pesquido de are, that does say that our international treaties, as a general proposition, don't have binding effect in our country unless they have given domestic effect. And so the issue for the government lawyer is not really, well, certainly not in this context, maybe it could be if you're at the State Department, is not what the CAT might say in the abstract, but what the positive law of the United States has told us the CAT means for us. And that means that you really do have to parse the one statute, and there's a federal criminal statute, which was at issue in these memos, and what it says to our courts and to our citizens, our legal obligations are. And so one set of arguments that is raised in this debate have to do with what people in France think our legal obligations are. And if we're talking to France as a sovereign, this may be a relevant subject to have a conversation in, but it's not really that relevant to a lawyer in the Justice Department who's being asked whether the executive branch of the United States may do X, Y, and Z, where the law that applies to the executive branch is a federal criminal statute and not the treaty writ large.